All rise. Please take your seat. Please take your seats.
Call the case, please.
Caribbean Court of Justice, Appellate Jurisdiction, Hearing of Appeal, CCJ Civil Appeal number DMC1 of 2019 between Hilary Shillingford and Angel Peter Andrew and Gloria Burnette Nee Shillingford. Please state your appearances for the court.
Good morning, Your Honors. If it should please you, Douglas Mendez leads me on behalf of the appellant. We are instructed by Ms. Cara Shillingford.
Dominica?
May it please you, my lords, Michael Rooney appearing with Miss Melissa De Freitas for the first respondent.
Thank you, Mr. Bruni.
My lord, I'm Gloria Shillingford, and I'm representing myself today in this matter.
Thank you, Mrs. Shillingford. Perhaps we could start at that point, Mrs. Shillingford. We realize that you are, as you said, representing yourself. That is fine. Will you just confirm that you did not make any written submissions to the court?
The reason why you're on the
No, sorry.
line,
Mrs. Shillingford, I just want to confirm that you did not submit anything in writing to the court.
yes, that's correct, Your Honor.
Wonderful. Okay, bear in mind that you will be given a chance to make oral submissions so that at the appropriate time it will be indicated, and you, of course, will then be able to put forward any oral submissions that you wish. So that in preparing for that, you may wish to listen very closely to what is being said, make notes or write down questions, and then, of course, you'll have a chance to make oral representations. Is that okay?
That's okay, Your Honor.
Thank you very much. You may be seated.
Thank you.
You may sit.
Please have your seat, Ms. Shillingford.
I'm sitting down, Your Honor. I am sitting.
We're glad to hear that. Okay, so Mr. Mendez.
Much obliged to Your Honors. With your leave, may I begin with the question as to whether the agreement between Hilary and Gloria is, as the courts below found, a concoction.
Before you do that, Mr. Mendez, and this will not necessarily come out of the time that you have, I assure you. We wanted some clarity as to where we are now.
Yes.
In terms of the judgments which were given in the courts below. As you will recall, the judgment by Mr. Justice Cottle was entered for Mr. Angel.
Sorry, how do you pronounce your client's name? Angel or Angel?
He is not my client.
Sorry, how is the name pronounced?
Angel.
Angel. Okay.
So it was entered for Mr. Angel Andrew against Gloria Shillingford for $1,222,700 for the completed sale, and then there were 2 sums entered for the aborted sale. The second defendant in that first proceeding was to hold 2 sums of money in trust for Mr. Angel Andrew. And then the first defendant there, Hilary Shillingford, your client, Mr. Mendes, was to indemnify Gloria Shillingford for all the monies paid to him. So that was a judgment given by Mr. Justice Cottle.
Yes.
That judgment was affirmed by the Court of Appeal,
Yes.
but there was a stay of execution put on that decision. But when the matter came before us and the judgment was delivered in February of this year, the stay of execution pending appeal was removed. So I'm just curious, and of course I don't know how much you can help us, but just curious as to whether you can tell us what is the state of play as regards the execution of the judgment.
May I make an inquiry?
Yes, of course.
The judgment has not been executed.
Judgment has not been executed. I see. Okay. I won't make too much of it because although that was stated that the stay of execution had been lifted,
Yes.
although stated in our decision, apparently when the order went out,
Yes.
it did not include reference to the stay being lifted. So
Oh, I see.
on this occasion, we won't make too much of that. So the point then is that all that was decided by Cottle J remains as he decided it, as far as you're aware.
As far
Nothing
as I'm
further
aware,
has been
yes.
done.
Well, I don't know what the position is in relation to Gloria Shillingford, but certainly as far as my client is concerned, it remains an unexecuted judgment.
Yes. Mr. Bruni, can you help us at all?
It's the same position here, my lords. We have not yet executed.
Okay. That's clear. Thank you very much. Sorry, Mr. Mendes.
Thank you.
Thank you very much, Your Honor. Your Honors, in the agreement between my client and Gloria Shillingford was first mentioned in the pleadings in Gloria Shillingford's defense at paragraph 6, which you'll see at page 365 of the record. It starts at the bottom of that page, as you'll see, in which she pleads that March 15th, prior to the sale, the defendant as agent for the claimant, and with his prior knowledge and consent, entered into a brokerage agreement with Hilary Shillingford concerning the properties. And then she mentions what the terms of that agreement were. She then refers in paragraph 7, that's on page 366, to an agreement that she had entered into subsequently with Clement Joseph and Connie Bell, another brokerage agreement. And that is the one, of course, that my client was concerned with as breaching his exclusive agreement. Then in Hilary's defense, which you will see at page 376, I think it is, at paragraph 7, he says, pursuant to the terms of the power of attorney, is referring to the power of attorney that Angel gave to Gloria, by an agreement between the defendant ancillary claimant, that is Gloria, and the first ancillary defendant, which is Hilary, made on the 15th of March, and then he refers again to the exclusive agency agreement, and he says that, again, this was with full knowledge and consent of the claimant, that is to say, Angel. Then Angel amends his statement of case, and which is addressing now the references to these agreements and so on. You will see at page 393, he deals with the agreement, and this is how he deals with it at paragraph 34. In January 2008, the claimant also discovered that without his knowledge or consent, the first named defendant, that's Gloria, or any other proper authority, the first named defendant, and had wrongfully and in breach of her fiduciary duties purportedly entered into an agreement with the first named ancillary defendant, whereby between May 30th and August 8th, the first named defendant purportedly paid to the said first name defendant the total sum of $582,000. Now, of course, from the evidence, what happened was that when Hilary discovered that there was a sale by virtue of the efforts of the other agents, Bonnie and I forget the other person's name, he then said, well, what about my exclusive agreement? You owe me money. And Gloria paid him the $682,000. And then he goes on to plead in paragraph 35 that the said first name ancillary defendant knew or ought to have known that the claimant had no authority to enter into the agreement with him or to pay the said sums to him, and that the said sums paid to him by the first name defendant rightfully belonged to and are due and payable to the claimant. So his pleading at this stage is very simply that Gloria did not have the authority to enter into this agreement with you, and therefore any money paid to you belongs to me, and therefore pay it back to me. There is, Gloria, afterwards, then, I think in her amended defense, she then addresses Angel's amended pleading, and you'll see at page 423, paragraphs 43 and 44. She repeats what she had said before, basically, at paragraph 44. On March 15th, prior to the sale, the defendant as agent for the claimant, and with his prior knowledge and consent, enter into the brokerage agreement with the first ancillary defendant. So she again pleads that this was done with his knowledge and consent. And at paragraph 45 on page 424, she pleads that as a result of the sale of the properties within the exclusivity period of the brokerage agreement with Hilary, he also claimed to be paid the amount by which the purchase price exceeded $3 million as his commission, and to date, with the knowledge and consent of the claimant, $420,000 was paid to Mr. Shillingford as commission. Now, the Angel then filed a reply to the defenses and also to the counterclaim that Hilary put in, because Hilary put in a counterclaim saying, well, under the brokerage agreement I had with Gloria, I am owed $1.5 million, so he puts in a counterclaim for the remainder. And he pleads to that. This is Angel at paragraph 20, page 440. The claimant denies that the first name ancillary defendant was at any time the duly appointed attorney of the claimant, nor was the first named ancillary defendant appointed to negotiate the sale of, nor to enter into agreements to sell 2 portions of land, nor any land of which the claimant was registered, and so on. So he's denying that, well, first of all, the first ancillary defendant never claimed to be the attorney of the claimant. So there was a misunderstanding, it seems, in the pleading, so that he was responding to something that Hilary never alleged. But in any event, the point is that he denies that Hilary had any authority to sell the property. And then at paragraph 25 on the following page, and this is the paragraph on which Angel relies in his submissions, he says, furthermore, the claimant states that any payment made to the first ancillary defendant, as alleged in paragraph 4 of the counterclaim, was unlawfully and or fraudulently made to the first name ancillary defendant by the first defendant ancillary claimant, and wrongfully and unlawfully received by the first defendant, inasmuch as the first name ancillary defendant was unauthorized to act for and on behalf of the claimant and perform no services for the claimant or with respect to the sale of the claimant's land, as would entitle the first ancillary defendant to the payment of any commission from the proceeds of sale. So again, when read in context, what he's again saying is that Hilary did not have the authority to sell the property on his behalf, and therefore any monies that he received, he would have to pay back. He does use the word fraudulently, but he never explains exactly what was the fraud involved in the case. So when you look at the pleadings, therefore, you will see that there is never any pleading that the agreement between Hilary and Gloria was a concoction, something that was made up after the fact in order to fleece Angel of his money. There was never any such agreement, any such pleading. The pleading was simply, I did not authorize that agreement, contrary to what both Gloria and Hilary were saying, and Gloria had no authority to enter into that agreement with Hilary. Hilary was therefore unauthorized, and therefore any money that he received pursuant to that agreement, he had to pay back to me. And that was basically what the case was about.
Well, paragraph 25, Mr. Mendez, does add that it was unlawful, no authority, but it does add it was unlawful and or fraudulent. I accept no particulars of fraud are given.
Correct. Well, it does
That's what I
say...
mean. So the no authority is not simply limited, I assume, to no authority because there was no power to delegate. But there are elements that paragraph 25 raises that in some form or fashion
It was fraudulent.
It was fraudulent.
Yes, but...
I accept that the particulars of no particular fraud are listed or given in that paragraph.
Yes, but if you look at the wording, quite apart from the fact that there are no particulars of fraud, which is a major flaw in any pleading, you must particularize fraud. What he does say, if you read it again, furthermore, the claimant states that any payment made to the first ancillary defendant, as alleged in paragraph 4 of the counterclaim, was unlawfully and or fraudulently made to the first ancillary defendant by the first defendant ancillary claimant, and wrongfully and unlawfully received by the first ancillary defendant, in as much as.
Not authorized.
So those are the particulars. As a matter of fact, these are now the particulars of fraud that he is referring to.
Is the unauthorized delegation of power to act.
And that is what the pleading says.
Right.
So again, it is, the word fraud is used there, but it is used improperly with respect, because what he is talking about is that Hilary did not have the authority to act on his behalf, and therefore he had no entitlement to any commission under the contract.
Yeah, he goes on, yes, it goes on to say, and perform no services. How does that fit in today? If we regard these as particularizing the fraud.
Well, if he says he performed no services for the claimant, I imagine that, again, that I suppose he's saying that because you were unauthorized, anything that you didn't do for me. It was not on my authority, and therefore whatever you did not do for me. But it could also fit into another pleading, but again, it's not put that way, that even if the agreement was a valid agreement, even if it was authorized, then you're still not entitled to the commission because you didn't do anything for it. I suppose it could be interpreted that way, but again, that's not the thrust of the pleading. The thrust of the pleading is that Gloria had no authority to enter into this agreement with you, and therefore you had no authority to act on my behalf, and therefore you were never entitled to any commission at any point in time. So it's on that basis we say that it was not open to the trial judge to make the finding that he did, that the agreement was concocted, and therefore, similarly, it was not open to the Court of Appeal to uphold that finding. It was simply, it would be a breach of...
But therefore, on a issue of fact, plainly wrong.
Plainly wrong. And more than that, it would be in breach of my client's constitutional rights to a fair hearing before the High Court.
I need some help here, Mr. Mendes. Why was it not open to the trial judge to make that finding?
Because it was not pleaded. It was not an issue in the case, and therefore it would not have been an issue that my client would have come to the trial to address.
If in the course of the proceedings, the evidence is elicited that something fraudulent occurred, are you saying that the judge is precluded from making the finding based upon the evidence which emerges?
I am saying that that is so, because in all cases of pleading of fraud, if you're going to make a finding of fraud, at least you have to warn the defendant somehow that it is open to the judge to make that finding. But it begins with the pleadings. If your case is that the agreement does not exist, it never existed, you're just making it up after the fact in order to steal money from me, then that is something that has to be pleaded from the start. If that was the pleading, then both Gloria and Hilary would have, I am sure, been asked from the attorneys representing them to provide instructions that the agreement existed from March 2007. But that was never an issue. The issue was not whether the agreement came into existence when they said it came into existence. The issue was whether Angel authorized it, whether he knew of it and he consented to it.
And that's
that was
the
the issue of
evidence
fact.
around the conversation in the lawyer's office.
That was all. That was what the evidence
That's
was about.
going to the fact that Angel knew and approved.
That's correct.
Mr. Mendes, just remind me, what did your client say to the Court of Appeal about this pleading point?
Whether they took the point that it was not pleaded, I can't say. I will have to ask. It's not clear. I can't say that the point was taken in the Court of Appeal. But it doesn't appear from the judgment that it was addressed, so I would assume that on the assumption that the Court of Appeal will have addressed such an important point, I can only assume at this stage that it was not taken before the Court of Appeal.
Is there any authority that you can point me to which says that if evidence emerges of fraud, it is not open to a court to find fraud?
Not off the top of my head, but I'm certain that I will. I will provide it at a later stage.
I would be anxious to see it because it goes contrary to what I had in mind was the law. But like I said, I'm really open to being persuaded otherwise.
Yeah, yes, Your Honor. Certainly we will. But of course, I would then have to rely on Mr. Bruni, and he hasn't done so, to point to the evidence of that fraud in the trial and point to the exact point in time when that issue arose, so that my client would have had the opportunity to respond to it.
Oh, but Mr. Mendes, I can myself just off the top tell you, and I think as my sister indicated, the cross-examination in relation to the signing of the agreement, etc., when it was stated by Hilary that Angel was on a phone call and specifically authorized Gloria to sign that agreement, the judge found that that did not happen.
Yes, but that goes to the question whether Angel knew of the agreement and consented to it.
Yes.
That was the pleading in the case.
Yes,
but whether
go ahead,
I'm sorry,
go ahead.
but the point is that the agreement can exist. The agreement can be authorized in the sense that Gloria had the authority to enter into it under her power of attorney, but nevertheless, it was not one that Angel knew of and consented to when it was entered into.
Just allow me this one little point. If I, as a trial judge, am told that this agreement, which is produced before me, was entered into in these circumstances, and a narrative is given to me as to the circumstances in which it was entered into, including the fact that the person ultimately affected by it is on the phone and authorizing it, and I find that that did not take place, then the step of saying that notwithstanding I was lied to as to how this agreement was made, for me to be asked to find nonetheless that the agreement was made, I find that the circumstances described is a lie. But to be asked to say, but nonetheless the agreement exists, is really a stretch.
Well, no, Your Honor, I think that it is quite possible to make the finding that the agreement exists. It's physically existed. It was put into evidence.
Well, the document exists, yes.
Yes, and nobody suggested that the document itself was not authentic. What the dispute that between the parties was as to whether Angel contemporaneously knew of it and consented to it in the course of the conversation that you have just mentioned on the phone. So that the judge could have found no, Angel did not consent to it. He did not, it was not without his knowledge. Sorry, it wasn't entered into with his knowledge, but nevertheless it was entered into.
But Mr. Mendes, in terms of paragraph 25, we interrogated it. That could, for the purposes of paragraph 25, be what was intended by the plea, fraudulent by reason of no authorization to act. In other words, if the trial judge concludes that on the evidence, I disbelieve that Angel was called from the lawyer's office, etc. On that fact, I believe Angel, and I disbelieve Gloria.
Yes.
And that is the only evidence put forward to say that Angel authorized
Yes,
it.
yes.
Paragraph 25 purports to say it was unlawful and fraudulent by reason of, first, no authorization to act, and
Correct.
as our sister pointed out, no performance of services. Would that fall within paragraph 25, unlawful and or fraudulent because there was no authorization to act? Forget
Well-
about whether or not standing on its own, Gloria could under the POA have done it.
Well, then it would, because what was pleaded by Gloria and Hilary was that you knew about it and you consented, because that was pleaded,
Yes.
obviously Angel is responding to that.
Yeah.
He's saying, I did not know about it. I did not consent to it.
So if the trial judge believes the latter,
If he believes the latter, then the next question that he has to answer still is, well, as he did, was whether Gloria had the authority to enter into it without Angel's authority and consent, without his knowledge and consent.
now, the trial judge concluded as a question of fact that the Court of Appeal upheld that Angel did not consent. On that piece of evidence,
Yes.
the trial judge preferred the evidence of Angel.
Yes.
Is there any fault in that?
W-
In terms of your critique of the finding of fact?
What we are critiquing is not the finding of fact as to whether he knew and consented. What we are concerned, at least this part of the appeal, what I'm concerned with is the finding which...
The conclusion, it's a conclusion that it was a fiction.
that it was a fiction, that it
I know.
never existed.
I understand that.
In the sense that it was brought into being for the purposes of fleecing him of his money, which I would imagine was, could be, well, you brought that into being after the sale, after you sold the property for $4.5 million, the two of you got together and you decided, you know what, we're only going to give Angel $3 million and we're going to keep the 1.5 for ourselves. And how are we going to justify that? We are going to bring this agreement into being. We're going to date it before the sale and say that we had this agreement beforehand and you became entitled to the $1.5 million. Now that is what the judge in effect found by saying that there was a concoction and a fiction. That is an entirely different thing from saying, I did not know of it and I did not authorize it. The question then would be, in the absence of his knowledge and authority, that is Angel's direct knowledge and consent to the agreement when it was entered into, does that mean that it is in law unauthorized? That is to say, that Gloria didn't have the power to enter into it. That is a separate question.
Yes?
And you take us to the point that by way of law, you say that that authority of Gloria
Yes.
has been proved.
Because of the agreement is there.
Yes.
And, sorry, the power of attorney is there. And, of course, the question is whether, in this case, the particular agreement that we are relying on, the exclusive sale agreement, the exclusive, however you want to phrase it, whether that agreement is beyond Gloria's authority. The courts below found that it was beyond her authority because in effect, she was passing on her own powers under the power of attorney to Hilary, which she is not authorized to do. And the question is that what the agreement did? Is that what the parties intended by that agreement? And of course, that is a second point that I will come to. If, of course, I can't get past the first point, which is that it's a concoction and that it is a fiction, well, then this court would I imagine, have to follow its previous decision, that is on Gloria's appeal, to say, well, there's nothing for us to discuss because the agreement doesn't exist or didn't exist. It's a concoction. I emphasize the point that Hilary came to the High Court clothed with his right under the Constitution to a fair hearing. And part of a fair hearing requires, in the first instance, notice of the charges that he has to answer. And particularly in a case where you're alleging fraud, you must particularize that fraud in your pleadings, subject, of course, to any authority that would suggest that if it arises during the course of the trial, and under what the judge will have to do in those circumstances, I would respectfully submit that if that question of concoction and fiction arose, which is a different issue from whether there was consent and knowledge, but if it was somehow some evidence of concoction and fiction arose during the course of the trial, and the claimant wished to rely on it, then you'd have to make an application to amend in the first place, or at least indicate to Hilary that you now have to answer this question of concoction and fiction.
I thought that was dependent on the cases that you might find to respond to Justice Barr.
Well, I'm anticipating that they would not go so far as to say that you can be surprised by that finding in the judgment of the court. And it was the first time that you're hearing of concoction and fiction is when you read it in the judgment of the court. I suspect that if the evidence arises during the course of the trial and that the authorities would say, and even if they say to the contrary, I would ask this court not to follow any unfair ruling of that nature. That the evidence arises and you don't give the defendant an opportunity to respond to it by adducing evidence to say, well, it was not a fiction at all, it existed. And it existed from that point in time, before any talk of a sale through the other brokers.
Counsel, I am really very, I want to be at pains to indicate to you that what engages me is that the whole case was conducted on the basis that the exclusive agreement was, in fact, not something to which Angel agreed.
Yes.
That was fundamental from the start.
That was the issue of fact that engaged the court, yes.
Right. So Hilary knew that Angel was saying, I did not know about this agreement.
Yes. And
Gloria knew that Angel was saying, I did not know about this agreement. Therefore, at a minimum, they each knew that Angel was saying that the statement that this agreement was made in the circumstances which you are now saying, that is fraudulent, that is a dishonest, it's a wrongful, it is an inaccurate statement. And that is what Angel was saying.
I appreciate that, but that only takes us this far. It says that, well, you can't rely on that agreement. Assume, for example, that Gloria did not have the authority to enter into it. You can't rely on it on the basis that I knew of it and consented.
No, it goes further. No, Angel is saying it did not exist.
Well,
that which you say took place, the signing of that agreement on that day at the MP's office, that did not take place.
No, with all due respect, Your Honors, he does not say that in his pleading. He does not say it does not exist. He says that agreement, I did not know of it and I did not consent to it. That's what he's saying.
Right.
And the court had to determine as a matter of fact whether he knew of it and consented.
Right.
And that was it. They did not have to determine because he never alleged that you made it up after the fact, that never existed.
What implicit in his saying that he didn't know about the existence of it is the proposition that that which you are saying attended the creation of it. That is a fiction.
With due respect, no, that can't be what he is saying.
Okay.
Because that goes to something else.
Okay.
That goes to saying that this thing is something that is made up after the fact, simply to cover yourselves because you've only given me $3 million and now you want to spirit away the 1.5.
I assure you, I will go and look at the transcript of this exchange again after this to persuade myself that I am missing your point.
Your Honors, the point that I am making is that whatever or however the cross-examination went in this case, it would have been directed and ought to have been directed only to the pleadings. And the pleadings in this case were that there was a dispute on the pleadings as a matter of fact as to whether there was knowledge and consent. So the cross-examination would have been on that basis.
Okay.
If at any point in time the cross-examiner had suggested to the witness that this was a concoction, you made this up, it never existed, that this sale went through and the two of you got together in order to fleece my client of $1.5 million, then the judge would have had to stop him and said, sorry, Mr. Bruni, I think it was his did the trial. You can't raise that because it's not pleaded.
Okay, yes, Mr. Menez, I think we can move on.
Much obliged to you. So that, under the assumption that the court is with me on that point, the next question, of course, is whether this is, what does this agreement provide? Is this a divesting by Gloria of the powers that she has under the power of attorney, which of course she's not authorized to do, or is it just simply the ordinary real estate agreement that the parties would normally enter into, that you go out and find a purchaser for me, and on the basis of that you would be entitled to a commission. Now, before I get to the actual terms of the agreement, if I can just direct your attention as quickly as possible to the Rainy Sky decision. This is a decision of the Supreme Court, or is it the House of the Supreme Court of the United Kingdom, and just a couple paragraphs at page 1907 of the record. This would be paragraph 21. I think this is the judgment of Lord Clark, where he says, the language used by the parties will often, just a couple of passages I'm referring you to very quickly. The languages used by the parties will often have more than one potential meaning. I would accept the submission made on behalf of the appellants that the exercise of construction is essentially one unitary exercise, in which the court must consider the language and ascertain what a reasonable person, that is, a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract, would have understood the parties to have meant. In doing so, the court must have regard to all the relevant surrounding circumstances. If there are two possible constructions, the court is entitled to prefer the construction which is consistent with the business common sense and to reject the other. And then on the following page, paragraph 25, this is a quotation from what Lord Steyn had said extrajudicially, with which Lord Clark expresses agreement. Often there is no obvious ordinary meaning of the language under consideration. There are competing interpretations to be considered. In choosing between alternatives, a court should primarily be guided by the contextual scene in which the stipulation in question appears. And speaking generally, commercial-minded judges would regard the commercial purpose of the contract as more important than niceties of language. And in the event of doubt, the working assumption will be that a fair construction best matches the reasonable expectation of the parties. And there's a similar passage on the following page, at the top of page 1909 of the record. Again, this is a quotation from Lord Steyn, which I will not read to save time. But at the bottom of the page, you will see a reference to what Lord Bingham said in Homburg, Utimport. He says the rule to which Lord Halsbury alluded in Glyn and Magiston, that a business sense would be given to business documents. The business sense is that which businessmen in the course of their ordinary dealings would give to the document. And then he goes on. 3 other cases merit brief reference. The same approach was adopted by Lord Justice Arden in Re Golden and by this court in Re Sigma, where Lord Mann said the resolution of an issue of interpretation in a case like the present was an iterative process involving checking each of the rival meanings against other provisions of the document and investigating its commercial consequences. The other principle that we rely on in this case comes from the case of C versus D, and that is the principle which you will see at page 1950. And this is a quotation that the court accepts as a principle. If the words used in an agreement are susceptible of 2 meanings, one which would validate the instrument or the particular cause in the instrument, and the other render it void, ineffective, or meaningless, the former sense is to be adopted. So that's the approach that I would ask you to adopt when you look at the agreement and seek to determine what exactly it means.
But Mr. Mendez, all of these decisions that you've pointed us to are cases involving commercial transactions.
Yes.
Are you suggesting that this principle applies outside of commercial agreement context?
I'm saying that this is we are talking about a commercial agreement here. An agreement, it is a commercial agreement.
You're suggesting that the agreement between Hilary
And Gloria.
and Gloria
Yes.
is a commercial transaction.
Falls within this context, and it is to be interpreted in that context. What makes business sense to the two persons involved here? One seeking to find a sale for property, and the other one offering his services to assist in that venture. Essentially, that's what it amounts to. In that regard, I will ask you to, I'm sorry. Yeah.
Yes, I was just going to observe to you that this court, in a case from Guyana, held that the very construction that you are arguing for applies even to the interpretation of wills. So that the principles are universal.
Well, I'm grateful for that observation, Your Honor. But I'm sorry, it didn't occur to me that the question will arise whether it applied to this particular
given the
contract.
context, you're in a family context.
Yes.
Angels, brother to,
Yes.
and so on. I thought that you would have looked at this transaction a little bit more differently from a business transaction.
Well, I imagine that
because you're going to interpret the power of attorney now, aren't you?
Well, I'm going to interpret
I know you'll interpret the agreement later on.
Yes.
But you're going to tell us that you are interpreting the power of agreement, which is an agreement between brother and sister.
Yes, that is correct. But it is between brother and sister, but it is between one person exercising a power of attorney, which is the vendor, or someone standing in the shoes of the owner of the property.
It doesn't have the color of a commercial context, does it?
Well, you can have a commercial agreement between brother and sister. The fact that the persons are related doesn't mean that it is not a commercial contract. And if it is that the same principles apply to a will as you have just suggested, then I would want to venture to suggest that the same principles apply. In other words, you're trying to make sense. You're trying to make sense of what the parties intended, and apply a business common sense approach to the words that they used.
Thank you.
I think that's as far as I can take it. Your Honor, I am not aware of any principle that would say that the approach that the court is suggesting in this case is not to be applied to a brother. Let's assume for a moment it was not brother and sister, that this was any person and a real estate agent.
I'm certain you're aware that when you're dealing with a brother and sister or family arrangement, there are certain presumptions which attend those transactions. The presumption of intention to create legal relations,
Yes.
for instance.
Well,
I'm just trying to situate your commercial common sense or business common sense in the context of the case with which we are dealing. As I
Yes.
said, this court sort of supports you
yes.
in its decision that the principle is to be applied to wills. But I
Yes.
don't think that the dictum to which you referred us
Yes.
by itself would be helpful to us. I think that our decision, I don't remember the name of the case, is perhaps the thing that saves your argument.
I think that I referred to it.
But in any event, Mr. Douglas Mendez, you are willing to accept reliance on the case to which my brother refers.
Absolutely.
Yes.
Absolutely. I'm grateful for
Indeed.
the
So
reference.
maybe we could
Yes.
move forward.
Yeah, I think it is one of the cases that we referred to, which in our submissions, I believe it is, I recall is a case from Guyana, but which referred to the English authority that we had relied on as well.
Yes.
Yes. If I can take you, again, I'm very conscious of time, if I can take you to the decision in Dennis Reed Limited against Goody, which is at page 1923, and this is from the judgment of Lord Justice Denning, where he says,
1923?
1923, yes. Yes, please, Your Honor. And he says, just from about here, when a house owner Are you with me, Your Honor?
Yes.
When a house owner puts his house into the hands of an estate agent, the ordinary understanding is that the agent is only to receive a commission if he succeeds in effecting a sale. But if not, he's entitled to nothing. That has been well understood for the last 100 years. The agent in practice takes what is a business risk. He takes on himself the expense of preparing particulars and advertising the property in return for the substantial remuneration reckoned by a percentage of the price, which he will receive if he succeeds in finding a purchaser. So that's the context in which he says the following words. No particular words are needed to create the relationship. All the familiar expressions, please find a purchaser, find someone to buy my house, sell my house for me, and so on, mean the same thing. They mean that the agent is employed on the usual terms, but none of them gives any precise guide as to what is the event on which the agent is to be paid. The common understanding of men is, however, that the agent's commission is payable out of the purchase price. That was relevant to that last question, payment out of the purchase price is relevant because what was being said what was claimed in this case is that the commission was owed simply by introducing the buyer, even though a sale did not occur at the end of the day. If I can ask you to take very quickly as well a look at the decision of the Ontario Court of Appeal in Gallan against Alenco. It's an authority which we submitted yesterday. And you will, at page 2206. 2206. 2266, I'm sorry, 2266. In the paragraph at the bottom of the page, it says the right of the plaintiff and the liability of the defendant depend upon the terms of the agreement made between the plaintiff and the defendant and upon the consideration of those terms. In my opinion, the language of the document entitled Exclusive Authority to Sell, assigned by the defendant, is free from any ambiguity whatsoever, and there is not room for any controversy as to the facts. The authority of the plaintiff as agent for the defendant to sell the property was by explicit provision in the document an exclusive one. In my opinion, the effect of that provision was to bar all other persons, including the defendant, from selling the property during the currency of the authority in such a way or by any means so as to deprive the plaintiff of his right to a commission of 5% of the sale price. That was a case in which the property was sold by not through another agent, but by the owner of the property himself, and the agent was claiming the commission nevertheless. But the point is that, again, the language that is used in the context of real estate agents could also be exclusive authority to sell, which is what Justice Denning was saying in that case. So if I can take you to the agreement itself now, which is at page 757, I believe. And you will see that it says that agreement made this 15th day of March between Gloria Shillingford, the lawful attorney of Angel Peter Andrew, now resident in London, England, hereinafter called the attorney of the one part, and Hilary Shillingford of Salisbury of the other part. Whereas the attorney has power to sell a property at Salisbury belonging to Angel by power of attorney dated 22nd November 2005, the said Angel is anxious to sell same. Witness as follows. Hilary Shillingford is duly granted the exclusive right to sell the property described in the schedule attached hereto. Now, if we stop there, that is language that is not uncommon, as I've just pointed out, in real estate contracts. That is to say, contracts between the owner of a property and a real estate agent. That is not unusual. Goes on to say, the said right shall extend for a period of 6 months from today's date. Again, that's not unusual. It is an exclusive contract, but it lasts only a period of 6 months. During that period, Hilary Shillingford shall diligently at his own cost do all in his power to sell the said property. Again, that's not unusual for a real estate contract. You at your own cost, you advertise the property, you seek out purchasers, etc. Because, of course, at the end of the day, you have a big payday if you do get the property sold. The property shall be sold for not less than $3 million EC, and the attorney shall receive the said $3 million on the sold price. So that, again, it is not unusual either, as one of the cases I refer you to set a price in the real estate agreement. That is to say, the owner of the property says that you're not to sell it for less than this amount. And then it goes on, if the property is sold for more than $3 million, the difference over the above of $3 million shall be paid to Hilary Shillingford as commission. Now, the assumption in those two paragraphs is that the property is being sold by the attorney, and once it is sold and the purchase price is received, then the attorney then pays Hilary the commission that is due under the contract. And then it says if the property is sold for exactly $3 million, then no commission shall be paid to Hilary. So it's $3 million, you get nothing. On no condition shall the property be sold for less than $3 million. We are suggesting that in the context, in the particular context, interpreting it as reasonable commercial persons would interpret it, applying the principle that I've just referred to. What the parties are seeking here to do is not to vest in Hilary all of the powers that Gloria had under her power of attorney. What she's seeking to do here is to elicit Hilary's assistance in finding a purchaser for the property. In other words, they're entering into a common or garden real estate agency contract whereby the real estate agent will find a purchaser, and in exchange for finding the purchaser, the real estate agent would be paid the commission. And that, we ask you to interpret it in that context. It is open to that interpretation. And in order to save it, if there are two interpretations, one which would make it valid, the other make it invalid, you adopt the one that would make it invalid.
Do we have the option of looking at the substantive terms of the agreement? I noticed paragraph 3 mentions a floor of $3 million. And then, of course, paragraph 4 says anything above that
Yes.
is basically to the agent.
Yes.
There was an aborted sale of the said property sometime before.
Before this one, yes.
Yes. Do you recall what the price was in relation to that aborted sale?
$4.4 million.
So it looks a little strange. If you were negotiating for $4.4 million, and in fact I gather the deposit was forfeited, it's a bit strange then to compare that with paragraph 3, where the amount that is to be accepted is just $3 million. Isn't that a little puzzling?
No, it's saying that it shall not be sold for anything less than $3 million. So,
Yes. So it can be sold for $3 million.
It can be sold for $3 million,
Yes,
but
but
not
it
less
was on the
than.
market not long before for 4.4, and there was a contract for 4.4. So why would the vendor accept $3 million when not long before he was selling it for 4.4?
You mean Gloria? Because
Yes.
the premise that we are operating on now is that the agreement is being entered into with Gloria.
I understand, yes.
And Gloria has entered into this agreement.
Well, Gloria has certain fiduciary relationship with ships with her brother,
Yes.
Angel, surely.
Yes.
And I think that your opponent is pleading the issue
Nephew,
of,
not brother. So.
of breach of fiduciary duty. How is it that she's entered into this contract allowing the property to be sold for $3 million, but not long before it was being sold for 4.4?
Well, Your Honor, that is a question that you would have to pose to Gloria, because you raise the question of breach of fiduciary duty.
Yes.
As far as Hilary is concerned, Hilary has entered into a contract with someone who has a power of attorney.
Yes.
And therefore, one would assume that that person had the power. You assume that you have the power to enter into the contract. If there's a breach, if the terms of the agreement itself that Gloria entered into itself amounted to a breach of fiduciary duty on her part,
Yes.
then she would have to answer to the owner of the property.
So
But as
you're
far as
saying-
Hilary is concerned, he's entered into this agreement, and he's entitled to insist that it be complied with.
That will not affect, in other words, the validity and the operation of the contract.
It would
between
not affect the
Hilary
validity and
Gloria
operation of the contract,
I
but it
see.
may affect the relationship between Gloria and Angel.
And Angel. That's it.
Well, I think it operates even more strongly for you because my recollection is that Hilary explained that as he understood it, Angel was now desperate for money, and therefore the lesser price was more acceptable to him now.
Well, that was the evidence that he gave, that it was not surprising to him because he had been asking for money and money had been loaned to him on a number of occasions. So it wasn't surprising to him that he would have accepted $3 million if they could have sold it for that.
So there's your explanation.
But then again, that's relevant only between...
But that's not has nothing to do with Hilary. That's a matter for Gloria and Angel.
But wasn't there evidence that Angel had stipulated that the land should not be sold for less than $3 million? Isn't there evidence that he stipulated that the thing should not be sold for less than $3 million?
I do recall that, yes, Your Honors, at some point in time in my readings. But if we can... I'll see if I can find the reference to that. But again, that would support, that again would be in support of Gloria's case. She would be able to refer to that evidence to say, well, the agreement that I entered into, Hilary, should not have been a surprise to you because you were prepared to accept $3 million. But as I said, that is a case for Gloria to answer, not for Hilary, who has entered into this agreement and is now complaining, well, it was an exclusive contract and you contracted somebody else to sell it. So, Your Honors, if you... What's this? Yes, Your Honor, so that if you accept our submission, which is that this is not to be interpreted as an agreement by which Gloria is divesting herself of the powers under the power of attorney, but it is a common or garden real estate brokerage contract, then I go on to the next question. I don't think that there's any dispute in the case that by contracting other persons to sell the property and then selling the property through them, that Gloria was in breach of the agreement that she had entered into with Hilary. The question, of course, is what would Hilary be entitled to under those circumstances?
Help me in relation to the agreement before you move on.
Yes.
The exclusivity.
Yes.
What enabled Gloria to give an exclusive? She didn't have one herself.
No, exclusive of, you mean of the angel himself?
That is actually what was in my mind.
Well, it would have been an interesting question if Angel then sold the property himself.
Right.
Whether in those circumstances the Hilary would be able to claim the commission in any event.
Well, we don't even have to go that far, because what stopped Angel from giving a power of attorney to another person or entering into a brokerage agreement with another person?
Precisely.
Yeah.
Now, the point is that there are cases, and there are some of the cases that we have attached to our case,
right,
which deal with the question whether when you are appointed a sole agent, if the language is that you are appointed a sole agent, whether that prevents the vendor from selling. And what if the vendor sells, can you claim the commission? And the answer is no. The answer is that the vendor is always free to sell the property himself, unless there's language in the agreement with the real estate broker that prevents the vendor from doing that.
My question is slightly different. That is, as between the vendor and the agent given the exclusive.
Sure.
In this case, the vendor, the owner, did not give an exclusive agency to Gloria.
Well, that is true, but what he gave to her was the power to sell the property on his behalf. So she is standing in his shoes as far as the sale of the property is concerned. The Court of Appeal below, and this is not an issue that is in dispute, has held that she does have the power to enter into a brokerage agreement, which meant that the brokerage agreement she entered into with the other defendants was valid, and therefore they were entitled to their commission. Now, as far as Hilary is concerned, she entered into that agreement with him, and she has said, and at the very least, what that agreement means is that I'm not going to enter into a brokerage agreement with anyone else Now, hang on, if I may have a minute, please, Your Honor.
I will hang on.
What I was going to say is that let's assume that Gloria is the owner of the property, so forget the power of attorney for the time being. As the owner of the property, she would be in a position to say that I am giving you an exclusive right to sell the property, which means that I am excluding anyone else,
Right.
and also I'm excluding myself.
Right.
Now, if Angel's power to sell is now vested in Gloria, then it would also include that power. To the extent that she, at any point in time, he could come to her and say, I revoke your power of attorney, I am going to sell the property myself. He can do that. Until that is done, she is vested with the same powers that he has, which would be a power, at the very least, to enter into an agreement with a real estate agent that would exclude anyone else, any other real estate agent being contracted to sell the property. Now, all we are concerned with in this case is the breach that occurs in this case is not Gloria selling the property herself, but that Gloria engaging another real estate agent to sell the property. That's what we are concerned with in this case.
It is that Angel did not give Gloria the exclusive right to sell. I think we agree was not the case. And if it is that Gloria, but Angel could, of his own, have granted such an exclusive right to someone as owner. Your argument is, well, having created the power of attorney, Gloria had all the rights and powers that Angel had,
Yes.
including the right to grant an exclusive power.
That's my point.
Is there a duty for Gloria, because what she was purporting to do is not what was given to her, to get the specific consent of Angel to grant the exclusive right to sell, or to Hilary? No.
No, Your Honors, because again, she is not divesting herself of the power to sell. At the end of the day, the sale can only take place through her. She's the only person who can authorize the sale.
Sorry, not the power to sell.
But
To get buyers.
Somebody
Enter
to get
the
a
real
buyer.
estate agency relationship.
I would respectfully submit that the power to sell that is vested in her, that would be vested in any vendor, would include with it the power to enter into an exclusive arrangement with a real estate broker to find a purchaser.
Yes, but was there in this context a duty on Gloria to inform Angel of that, because as between Angel and Gloria, that did not exist to Gloria's knowledge. In other words, Gloria knew that she was facilitating this, but Angel was also entitled to facilitate.
Well, Your Honor, there is no clause in the power of attorney itself that requires Gloria to obtain Angel's consent before she does any particular thing. As a matter of fact, if you look at the power of attorney at page 372, power of attorney at page 372, where I've marked in red there, it says, and I, the said Angel Peter Andrews, hereby agree, at all times hereafter, to ratify and confirm whatever the said Gloria Shillingford shall lawfully do or cause to be done in and concerning the premises by virtue of this deed. So that it is quite to the contrary. It is not requiring the obtaining of consent beforehand. Angel is saying beforehand, I am going to ratify anything that you lawfully do. And I'm respectfully submitting that the power that Gloria is given to sell the property would include the power to engage someone to find a purchaser, which is what the normal incident of ownership of property.
And you say that is what she could have lawfully done.
That is what she could have lawfully done.
Mm-hmm.
And having given Hilary the exclusive right to do so, she then acted in breach of that agreement when she contracted somebody else, and then there was a sale. Now, Your Honors, the question, of course, is, as I said, if you agree with me up to this point in time, well, then what is Hilary entitled to? Now, if I can ask you to look at the case of Black, Gavin, and Chalmers, which is a case that I sent yesterday, in which the principles are fleshed out. Essentially, the point is that Hilary is entitled to whatever the contract says that he's entitled to.
Give us the page, please.
This is page 2259.
Thank you.
It starts earlier than that, but I'm referring you to page 2259. And this is when at that page, in the second paragraph, beginning the applicable law. The applicable law should now be considered in the leading case of Real Estate Agents Commission, Luxor against Cooper. Lord Russell said, commission contracts are subject to no peculiar rules or principles of their own. The law which governs them is the law which governs all contracts and all questions of agency. No general rule can be laid down by which the rights of the agent or the liability of the principal under commission contracts are to be determined. In each case, they must depend upon the exact terms of the contract in question and upon the true construction of those terms. And then, if you drop down to the quotation at this point, in the Migley case, Lord Justice Jenkins said, as pointed out, an agency contract of this sort, just like any other contract, must be construed according to its terms. One has to look at the peculiar contract and see whether, according to its terms, construed in accordance with the ordinary principles of construction, the event has happened on the occurrence of which the commission is expressed to be payable. And then at the bottom of the page, more or less the same thing is said by Justice of Appeal Hogg. The right of an agent into whose hands a property has been placed for sale to remuneration depends in every case on the nature and effect of the contract between the owner. The plaintiff's rights must rest upon his contract. And on the following page, 2260, because of course these all cases are dealing with situations where you have an exclusive contract and then the property is sold by somebody else, either by the vendor, the owner of the property, or by some other real estate agent. And you'll see that this is said at the top of the page. It would follow from this point here, on the application of the principle that the rights of the agent and the liability of the owner depend upon the nature and effect of the agreement between them, that if provision is made to such effect in an agreement, an agent could obtain a commission when he had done nothing whatsoever to effect a sale. The right of an agent to commission in such circumstances has been recognized by the courts, and then reference is made to the case of Gallan against Alecno, which is the case that I referred to, you to earlier on. So essentially, that is the question is, does the contract in this case entitle Hilary to the commission of $1.5 million in the circumstances of the case? In other words, did the event giving rise to the entitlement to a commission occur in this case? And of course, that would depend upon a proper construction of the contract. If I can refer you to the case of Fisgard Capital Corporation, which is an authority which we referred to in our written submissions, page 1962. This is a clause that the court was construing. The agent acknowledges and agrees that it shall only be entitled to receive a commission as herein provided upon a purchaser assuming the mortgage interest or upon the completion of the sale of the property to a purchaser, as evidenced by the registration in the Victoria Land, the Office of Transfer, and so on. So those were the circumstances under which the commission was to be earned. That is to say, assuming, upon a purchaser assuming the mortgage interest or upon the completion of the sale. Again, the assumption of the mortgage interest in this case did not occur through the efforts of the real estate agent, but the real estate agent claimed the commission, and the court found that it was entitled to it. If I can ask you to look at page 1966. In paragraph 23, the principle is coming from the Black case that I just referred you to. If a vendor is party to an exclusive listing agreement with a broker and the property is sold through the efforts of another broker, the vendor may still be liable to pay a commission to the listing broker. And Black Gavin is cited. At the bottom of the page, you'll see that Gallan and Alekno is also referred to. And on page 1968, the court says at paragraph 29, paragraph 29, the court says, in the case at bar, Fisgard had court-ordered authority to list the property. It did so with Collier's. In my view, Clause 12 of the exclusive agreement does not limit Collier's entitlement to commission to a sale arranged by Collier's. The provision is clear that Collier's becomes entitled to the commission upon a sale closing during the term of the agreement, regardless of whether Collier's arranged the sale or introduced the purchaser to the vendor. And the last case that I wish to refer you to is a decision which we passed up this morning, that is McCallum against Williams. And you will see on the second page, we don't have a courier number as yet for the case, but I think copies were handed up to the court. No, not as yet.
I haven't seen any, but
Come by email.
Sorry, we provided your staff with copies of it this morning. But if I can ask you to look at the agreement itself. Come down. From here, if it can be blown up slightly so we can read it.
Mm-hmm. It's on courier. It's on attachment. Yeah.
okay.
Mm-hmm.
Thank you. Mr. Mendes, do you expect us to read this?
Well, if you look at the screen, we're blowing it up a little bit here. Unfortunately, we provided to you as we got it.
Okay.
It says, I hereby request W.D. McCallum or Science to register the real estate or property mentioned herein in his real estate register and constitute and appoint him my lawful agent and authorize him to sell the above described real estate or property for me and on my behalf at the price mentioned above and or at such lesser price that I may afterwards agree upon, and I authorize him to advertise such property in such manner as he may wish, such advertising, however, to be without cost to me, except such as is covered. And then in consideration of the said McCallum registering my said real estate or property for sale in his real estate register, I agree to pay him a commission of 3% of the price obtained whenever a sale of the property or any part thereof takes place. Said commission to be paid by me whether the real estate is sold either at the price mentioned above or at such other price that I may hereafter accept. So those are the terms upon which the commission was to be earned. Again, this is a case in which the property was sold by, I believe it is the owner of the property in this case. And if I can ask you to look at what the Chief Justice Townshend said. There's no
You have pages now, Mr.
You do?
Yes,
Okay.
2274 is the start. Yes.
7-8. So 2278.
2278.
This is the judgment of Chief Justice Townshend at paragraph 3. Referring to the agreement, he says, now it seems to me this language means and can only mean any sale of the property by whomsoever made. It will be observed that he engages to pay him the commission whenever a sale of the property or any part thereof takes place. It does not limit the payments to a sale made by plaintiff. If that had been intended, how easy to have added the words by him or equivalent words. We cannot add them. It is quite unnecessary to do so in order to give a clear meaning. The further words, and said commission to be paid by me, whether said real estate or property is sold either at the price mentioned, carry out and emphasize the previous sentence. It carefully leaves out any words which would confine the commission to a sale, only to a sale made by the plaintiff personally. And is certainly broad enough to include, as no doubt intended, any sale whatever by whomsoever made.
What paragraph are you reading from, Mr. Mendes?
That was paragraph
Sorry.
3.
3, oh, I got it, yes. Thank you.
And then on the following page, this is in the judgment of Justice Russell, paragraph 9.
I think we have that. It seems fair also to the member.
Sorry, yeah.
It starts, it seems fair also
Yes,
to the member.
it seems fair also to
I didn't want to trouble you to read it because your time has...
I'm sorry, Your Honor. But he's so if I can just
Yes.
take, even if I have just, I think this paragraph is important. It seems fair also to remember that the greater number of cases the purchaser would deal with the owner directly. He would not wish to buy a property without seeing it, and he would naturally wish to chaffer with the owner as to the price. In such cases, which it is fair to assume would at least be very frequent, the plaintiff would have brought about the sale, and yet under the judgment appealed from would be entitled to no commission at all events, unless he was able to prove the very difficult proposition that the sale had been brought about through his instrumentality. It seems reasonable, therefore, to interpret the contract, if possible, in such a way as to entitle plaintiff to commission in the event of a sale, no matter by whom effected. And again, if I can take you back to the terms of the contract here. The contract. Paragraph 4 says, if the property is sold, doesn't say by whom, for more than $3 million, the difference over the above shall be paid to Hilary Shillingford as commission. And I said, if the property is sold for exactly $3 million, then no commission shall be paid to Hilary. Again, it doesn't identify by whom. So we always...
Mr. Mendez, you can't have your cake and eat it too. You said that we have to interpret words in the contract in the context of the contract. So how should we understand sold here? It appears as though this is a contract between Hilary and Gloria, and only Hilary and Gloria. How are we to import other persons into clause 4?
Against the backdrop of the commercial realities of a real estate brokerage contract. This is why I thought it important to read the paragraph that I just did.
Sorry, but you, in all of the authorities that you've cited, said it depends on the terms of the contract.
Yes.
So I don't think that you, except you can bring sold within the context of these other commercial common sense cases to which you're referring us, that,
yes,
that will help us. Because this is a contract between Hilary and,
yes,
and Gloria. The contract talks about Hilary Shillingford is duly granted and so on and so forth. The only person who is contemplated to perform this contract is Hilary.
Yes.
So how do we transition to where you are attempting to take us? How do we get there?
Mr. Mendez, you have 3 minutes to respond
yes,
and to wrap up. Okay.
Thank you very much. I rely on paragraph 9 that I just read from the decision in McCallum, in which the court is saying that having regard to the context of the brokerage agreement, which is that ordinarily you would expect the actual purchaser to deal directly with the owner because they want to see the owner and so on and talk about the property.
Sorry,
it is against that.
Sorry, Mr. Men, but didn't that contract say sold by whomsoever or something?
No, it didn't. It says whenever it is sold. It didn't say by whomsoever. In other contracts, in the Black case, Black case, and in the Gallum case, the language was sold by whomsoever.
That's right.
The Fisgard case does not have that language. And this case that I'm referring to, which is the New South Wales case, does not have that language. It does not say sold by whomsoever, but the court interpreted it as meaning, even without those words, that you entitled the commission no matter who sold the property at the end of the day. Yes, and of course, I'm saying it in the context of an exclusive contract. She is giving Hilary for a period of time. All she has to do is to wait until that period of time expires before going elsewhere. For that exclusive period of time, Hilary is given the exclusive right to earn a commission. But the language of the contract itself doesn't say if the property is sold by you for more than $3 million, you get 1.5, but whatever the difference is. It says if it is sold, and it doesn't say by whom. As the Chief Justice in the case I just cited says, it would have been so easy to say by you. And it does not say so. But in the context of an exclusive real estate brokerage contract, respectfully submitted, is reasonable to interpret it to mean that you're entitled to the commission, no matter by whom it is sold.
That case.
Sorry?
I said one will have to look at that case.
I would appreciate if you do, Your Honor.
Okay.
And I'm much obliged, Your Honor.
Thank you very much, Mr. Mendes. Mr. Bruni?
Please, my lord. Maybe I can comfort my friend by letting him know that we do not argue with him that if the contract is a legitimate real estate contract between Hilary and Gloria, that his client would be entitled to the commission. But there are certain implications if that was the case. We had in the High Court case a decision by Justice Cottle whereby he pronounced that there was an award of $1.6 million for the first respondent, $1.671 million. And the court ordered the appellant to indemnify the second respondent in the sum of $420,700. That decision was appealed at the Court of Appeal unsuccessfully. And in the Gloria Shillingford case, which was decided by this court, the court confirmed the decision at first instance and had a judgment in favor of the second respondent, stating that the second respondent basically is entitled to the sum awarded in the court at first instance. So if the appellant is to succeed in this appeal, it would mean, in fact, that the effect of that particular judgment would be that this court has pronounced a judgment whereby it has held the agreement, which is the main subject of the dispute, to be invalid by virtue of the fact that Gloria never challenged its validity. The court, in fact, basically confirmed it was a concoction, and the very same court is going to say this is a valid agreement by which Hilary is entitled to his commission. So the effect of this would be that Gloria would have to pay Angel the money found due to him, which includes Hilary's commission, and that the court will order either Gloria or Angel, or a combination of both, I'm not sure, to pay Hilary another $1 million. So you have two issues. That the decision would be unjust, and there would be conflicting decisions by the same court on the same set of facts in cases involving the same parties. We are contending that this is an abuse of the process of the court. The fact that Hilary was not named as a party in the earlier appeal of Gloria is no fault of the first respondent. At the first instance, all three were parties. At the Court of Appeal, the cases were consolidated, all three were parties.
Mr. Bruni, would you agree that the judgment rendered by this court in February was very specific and very careful to underline the fact that its decision was in relation only to the parties to that appeal?
I agree. However, my lord, the effect of the decision. No, sorry. I should say that it is the Hilary's fault that he wasn't a party to that appeal. And the authorities will show me, Lord, that although he was not a party, a named party, the dispute was among the same three parties that were before the court at first instance and the Court of Appeal. In other words, and I'll emphasize, my Lord, that the leave was granted to both Hilary and Gloria on the same date. That was on the 19th of March, 2018. The parties were to comply with certain directions within 90 days, pay security for costs, and to file a list of documents, at which stage they would be entitled to a certificate of compliance, which means that basically March, April, May, by May, June, a certificate of compliance would have been available. The appellant in this case cannot deny knowledge of the pending appeal. The certificate of compliance was issued in August.
Yeah, Mr. Bruni, I think we are familiar with the chronology. The point of substance, though, is the one I raised earlier, which is that the decision given in February was specifically said to relate only to the parties to that appeal. Now, Mr. Shillingford, Hilary Shillingford, was not a party to that appeal, and he's now prosecuting his appeal before us. And he's saying that he's not bound by the decision taken by this court in February of this year. Are you going to contravene or say something contrary to that?
Yes, my Lord. We are saying that it constitutes an abuse of the process of the court. It's against public policy to relitigate these issues that were among the parties and that was actually settled by a final Court of Appeal. And in this regard, my Lord, I'll refer your Lordships to two cases: the case of Henderson and Henderson and the case of Johnson and Gore Wood. Johnson Johnson is the case, the authority which deals with the question of Appellant, and it has been interpreted in various decisions to import the question of abuse and principles of public policy. And I will just read the head notes, my lords, which is on page 2062 of the record. And the printing is not very clear, but I have a clearer copy which I'll read. It says, where a given matter becomes the subject of litigation in an adjudication by a court of competent jurisdiction, the court requires the parties to that litigation to bring forward their whole case and will not, except in special circumstances, permit the same parties to open the same subject of litigation in respect of a matter which might have been brought forward as part of the subject in the contest, but which was not brought forward only because they have, from negligence, inadvertence, or even accident, omitted part of the case. The plea of res judicata applies except in special cases, not only to points on which the court was actually required by the parties to form an opinion and pronounce judgment, but to every point which properly belonged to the subject of litigation and which the parties, exercising reasonable diligence, might have brought forward at the time. We are saying, my Lord, that the 10-month delay in instituting this appeal shows a lack of diligence on the part of the appellant. It also shows, my Lord, that the appellant has failed in his fundamental duty in accordance with the basic rules of the court, the primary objective, overriding objective, to have his matter dealt with without delay. And my Lord, a similar point is made in the case of Johnson Gore. And I'll only read for the purposes of this submission, point 2 of the head notes. And the Johnson Gorwood Limited is on page 2207 of the appeal, the record of appeal.
Yes.
One moment. 2207. Sorry, Melon, may I just have one moment in my little time?
Yes.
Yes, and it reads as follows on page 208, where a court had to decide on the strikeout application sorry, my lord, may I just consult my limit time?
Mr. Brody, it's very difficult to read some of these judgments. They were not, at least they're not user-friendly. Because we can't read upside down
Yes.
or
We do
sideways.
apologize for that.
Yeah, it should really be one page at a time and not 2 pages, Mr. Bruni. Please.
Yes, I
We do a
bear
lot
that in
of
mind.
reading in this job.
Yes, I'm sorry, but you see, I think we were a bit misguided by the new practice of the court that we don't have to submit authorities. So I didn't think we paid much attention to it because we got the impression that the court itself would be identifying its authorities.
Well, I don't know about the new practice, but I do know that we need judgments that we can read. Thank you, Mr. Bruni.
I appreciate that, and we'll make sure that we have this corrected.
Thank you.
It would seem, Mr. Bruni, if you are not going to submit authorities, then that's fine. But if you submit them properly.
I agree.
Okay.
And anyway, the point we are making in this, we're still trying to look at the authorities, my lord. The point we're making, my lord, is that the authorities have shown that it is actually an abuse of the process of the court and against public policy, where a litigant stands by and doesn't act accordingly to ensure that he is made a party to litigation. So that we are suggesting, my lord, that in fact the matter ought not to be litigated. It will result in conflicting judgments.
Did you say it would, or are you saying it could?
It could, of course it could. Because if the court was to find in favor of Hilary at this stage, what we'd have is one judgment saying this agreement is valid, invalid, another judgment saying the agreement is valid, one agreement saying that Angel is entitled to $1.6 million, and another judgment saying that Angel should pay $1 million out of that to Hilary, when Gloria has already been ordered to pay the 1.6 to Angel. So in effect, it would be overruling, the court would be impliedly overruling the first decision. And my lord, the case that I wanted to refer your lordships to a while ago, my learned friend, Mr. Freitas, has now brought it to my attention. It is actually the House of Spring Gardens Limited and others versus Wheat and others. It's on page 2066 of the judgment. And this time, this one can be read. The paragraph 2 of the head note, where combined defendants were stopped from pleading that a foreign judgment had been obtained by fraud in consequence of a judgment in a separate second action in the foreign jurisdiction, a defendant who had not been a party to the second action would nevertheless, because of the privity of interest between himself and the other defendants, be bound by estoppel if he had been aware of the proceedings and would have been entitled to be joined in them, but had decided without explanation not to apply to be so joined. Accordingly, the third defendant was privy to the estoppel binding the other prior judgment. Accordingly, the third defendant was privy to the estoppel binding the other prior judgment if it was not been obtained by fraud. Right. Sorry, let me just read that section again. The third defendant was privy to the estoppel binding the other defendants, and was therefore bound by the decision in the second Irish action that the prior judgment had not been obtained by fraud. Lord, if you look at the circumstances of this case, the record in the Gloria Shillingford appeal, which is contained in our submissions, in our authorities at page 2054 to 2061, will show that the case was heard on the 20th day of January 2019. If one looks at the certificate of compliance, which was issued by the registrar 10 months after it was issued on the date that the case was heard. And the court will take judicial notice of the fact that all its proceedings are transmitted by video conference. It is not difficult to assume that the appellant in this matter may have stood by looking to see how the first case had fared out before deciding whether or not to proceed. In fact, the appeal had not been filed when the first matter was heard. So in those circumstances, we are saying that the court, as a matter of public policy, should not have the matter re-litigated. In the interest of time, I refer your lordships without reading to the case of the same case, House of Spring Garden against Waite, and also the case of Johnson and Gorwood, which is in our submissions. And just briefly, I'll just read a little part of the decision from Johnson and Gorwood.
Counsel, let me interrupt you here.
Yes, sir.
What is it that your argument leads us to doing? Assume that you succeed. Could I finish? Assume you succeed in showing that this matter could be embarrassing. Assume, notwithstanding the difference in parties, etc., you make out that it is an abusive process or it's a possible abusive process, none of which things I'm saying you should take for granted, but just on the premise that those are made out. What do you want the court to do? To say to Hilary, your appeal cannot proceed any further and you are out of court?
My Lord, I would say that the court would dismiss the appeal against Hilary with cause in favor of both respondents.
Okay, I'm clear. Thank you.
Yeah. Before Mr. Abrune, I may have missed it in your authorities, but you were able to find any cases that deal with the matters at this stage of the proceedings?
The matter,
Abuse of process point.
Yes, we have it in our submissions. We refer to estoppel and abuse of process, and my learned friend had dealt with it in his response. In terms of our authorities, the abuse of process is contained on page 3 of our submission.
No, I'm asking, perhaps I'm not making myself clear, Mr. Bruni. Did you find any authorities which deal with what you are arguing at this level, at this stage, the apex court, and the two appeals coming and being dealt with separately, albeit arising out of the same proceedings below?
We didn't find any cases exactly on point, but the principles which have emanated from the various cases show that the principles can be applied widely enough to encapsulate the circumstances that we have with us now. And in fact, I was referring to the case of Johnson and Gorwood, where it is stated, again, we have a very bad record, but in our authorities at page, I think, 22, the case starts at 2207, but we also have it regurgitated in the respondents' submissions, written submission.
Thanks, Mr. Bruni. We'll pick it up from there. I don't want to delay you further. Thank you.
It says that there's an underlying public interest that there should be finality in litigation and that the parties should not be twice vexed in the same matter. This public interest is reinforced by the current emphasis on efficiency and economy in the conduct of litigation. It is the interest of the parties and the public as a whole. The bringing of a claim or the raising of a defense in the later proceedings may, without more, amount to an abuse if the court is satisfied, the onus being on the party alleging the abuse, that the claim or defense should have been raised in the earlier proceedings if it was to be raised at all. And the judges go on to say that one cannot comprehensively list all the possible forms of abuse, so one cannot formulate any hard and fast rule to determine whether on given facts abuse is to be found or not. It is, in my view, preferable to ask whether in all the circumstances a party's conduct is an abuse than to ask whether the conduct is an abuse. And then, if it is, to ask whether the abuse is excused or justified by special circumstances. Properly applied, and whatever the legitimacy of its dissent, the rule has, in my view, a valuable part to play in protecting the interests of justice. So, my Lord, I will leave that point and leave it to the court to deliberate. The defendant's second respondent's main argument really has hardly been tackled by my learned friend. A learned friend concentrated on the finding, the comment of the trial judge, and failed to address the fundamental issue when it comes to challenging findings of fact. My Lord, if one refers to the Court of Appeal decision which endorses the findings of the trial judge, there are several incidents where the judge found facts adverse to Hilary before concluding, both Hilary and Gloria, before concluding that the agreement was a concoction. And I will just refer your Lordship briefly to the various paragraphs of the Court of Appeal. It is paragraphs in particular 54 to 57. And briefly, in paragraph 53, the court expresses the principle that this court, I'm sure, is very familiar. An appellate court should not interfere with the judge's conclusion on primary facts unless satisfied that he was plainly wrong. There was not even a suggestion by my learned friend that the judge was plainly wrong. and the judge, the Court of Appeal, accepts findings, for example, the negative findings in respect of the credibility of Gloria, with respect to the payment of $45,000 in paragraph 57. He mentioned the fact that the payments would normally be made for the lawyer's office, but this time that particular payment was made out of the jurisdiction. He goes on to address in paragraph 55 that there were no supporting documents to support the loans that were allegedly made by Hilary to Angel and by Gloria to Angel. He also mentioned the fact that Hilary had admitted that he had reported to tax authorities, and that caused him to believe that Hilary's evidence cannot be relied on. And in paragraph 56, Portal J was caving on the exclusive agreement and likewise caving with respect to the credibility and honesty of Hilary. He gave cogent reasons for so finding. Portal J described the exclusive agreement as a fiction concocted by Hilary and Gloria in an effort to withhold from Angel a substantial part of the proceeds of his property. In my judgment, it was entirely open to him on the evidence so to find. He found that the payments made to Hilary were done without authority. He also found as a fact that there were no unpaid loans by Angel to Hilary. He found that the exclusive agreement was invalid. The judge's conclusions with respect to the central factors issues in this appeal present a formidable, if not a complete, impediment to the success of the appeal on the factual issues. The findings made by the judge were clearly open to him on the evidence and could not be said to be against the weight of the evidence. Portal J was correct in dismissing counterclaim, and the court goes on to cite the authority to show that even the absence of documentary evidence was something that the trial judge was entitled to rely on. It is significant that the trial judge did not only disbelieve Hilary, he disbelieved Hilary's witness, who was Shillingford, Gerald Shillingford, who said that one of the loans made to Hilary was done in his presence, and he counted $50,000 in cash in a paper bag. That was the evidence of the loan. Hilary himself had said, I'd gone to the bank to withdraw some of that money, but there's no bank document to support this particular transaction. And the Court of Appeal, of course, didn't upset the judge's finding of fact.
Mr. Bruni, excuse me, what do you make of Mr. Mendez's submissions then, that it was not open to the judge to find that the agreement, the exclusive agreement, was a fiction or a concoction based on the pleadings?
Well, in the first instance, I'll confirm, as evident in the Court of Appeal judgment, that this matter was never raised in the Court of Appeal, and because we didn't raise a preliminary objection, I allowed Mr. Mendez to continue uninterrupted. But let us not forget, my lady and my lords, that this case was a case that Angel brought against Gloria for breach of fiduciary duty. She alleged bad faith on the part, he alleged bad faith on the part of Gloria, and some of the bad faith involved Hilary. And in that regard, my lord,
bad faith, Mr. Bruni?
Bad faith. Bad faith and fraud. She did allege it in terms of the breach of, including her breach of fiduciary duty. If one looks at page 388 of the record, paragraph 5A, it says that the first defendant, that is Gloria, owed to the claimant fiduciary duties, including a duty to act in good faith and the best interest of the claimant, a duty not to act for a purpose collateral to the terms of the agreement, a duty not to place herself in a position where her personal interest did or might conflict with the duties owed to the claimant. Further, or alternatively, it was an implied term of the agreement between the claimant and the first defendant that the first defendant would act faithfully in the best interest of the claimant, use her best endeavors to promote the interests of the claimant. If one goes to page 393, that is paragraph 34. That's where Hilary comes in. It says in January 2008, the claimant also discovered that without his knowledge or consent, the first defendant the first defendant had wrongfully and in breach of her fiduciary obligations purportedly entered into an agreement with their first name ancillary defendant, Hilary, whereby between the 30th day of May 2007 and August 8, 2007, the first defendant purportedly paid to the first name ancillary defendant the total sum of $682,847. So if this is not fraud, I don't know what is. And the use of the word purported indicates dishonesty. And I'll just make one further point in that minute. Yes, and it is consistent with the judge's conclusion that it was concocted. Because there it is, the allegation is that it did not exist. The agreement did not exist. Did not exist in the sense that it was not a legitimate agreement. One can also look, my lord, at the circumstances in which this particular discovery was made as alleged by Angel, so that Hilary would have had notice through the witness statement of Angel Andrew, of Angel Andrew, which is contained in the record at page one moment, I will be right, page 600 and page 612, right? And I'll just read it very quickly. We went into Dominica, that is, Angel went to Dominica for a few days. Sorry, Melody, I think I'm
Yeah, you had outlined it. Highlighted.
I think I was reading from the wrong statement. I want to read this statement from Angel himself. I was reading the one from Amanda. On page 600, paragraph 74 of the witness statement, the evidence in chief. And I'll just read briefly or quickly. I had spoken to Hilary on the cell phone just a few hours before, and he had told me that he and Gloria had fallen out over some money he considered she had cheated him out of. He did not elaborate further. I called Hilary again, and we arranged to meet up later for that day for a drink, and I thought I would be given an explanation, but I did not keep that appointment. When Amanda and I updated Mr. Bruni, he advised us to report the matter to the police, which we did. The police promised to inquire into the matter and subsequently informed Amanda and I that Gloria had been questioned and had implicated Hilary in the matter. The police also informed us that they had questioned Hilary, who told them that he and Gloria had made an agreement and showed them a document signed by both of them dated May 2007, giving him the sole rights to sell the valley and awarding him as a commission any money received from the buyer over $3 million. The police gave Amanda and I a copy of the document which both of us were hearing of or seeing for the first time. And then the police said they couldn't take further action since it appeared to be a genuine signed contract and advised us to take further legal action. My lord, Hilary was defended by counsel Gloria was represented by counsel. In cross-examination of Gloria on page 1194 of the record. Yes, 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 yes.
Several objections at the beginning.
Yes.
Several passages.
Yes. Yes, and my learned friend was just pointed out that at the beginning of the trial, if one looks at the record, they had objected to several paragraphs of the witness statement. This was not objected to. So this forms part of the evidence in chief. Lord, we might have a little difficulty in terms of identifying the page of the bundle here, because I just as an aside, the appellant uploaded 2 sets of documents. One set contained a different set of numbering from the second set, and record number 3 had no numbers. So the number that I'm going to refer to would be in the original numbering from the Gloria appeal, which is uploaded in the present case. It's at for ease of reference is at pages 493 and 495 of the notes of evidence, but 1194 and 1195 of the record in accordance with the original number. The question in cross-examination. Let us watch Hilary's payments. You have payments. Look at page 110 to 115, which starts from the 19th of July. From the 19th of July, you paid Hilary $4,000 on the 20th, $3,000 on the 30th, that's page 112, then $70,000 on the 8th of August, $70,000 on the 8th of August, $17,000 on the 8th of August, $2,500 on the 9th of August, $1,500 on the 15th of August, then $3,000 on the 23rd of August. I am suggesting to you, Ms. Shillingford, that when you signed this contract on the 21st day of May 2007, and on the 15th of March 2007, that is pages 76 to 77, at the office of Mr. Barron on Kennedy Avenue, instead of going to Mr. Angel Andrews' lawyer in Cross Lane, Church Lane, that it was part of a plot by you and Hilary to deprive Angel Andrew of $1.5 million. Answer, that's not true. That's totally untrue. I was never part of no plot. No objection by counsel to the question. No question of pleadings and lack of pleadings were raised. But Lord, when one looks at the evidence as a whole, manner of payments, the imaginary loans, you know, the fact that the judge accepted Angel's evidence that he was totally unaware of the agreement and the circumstances in which he found out about the agreement. The circumstances, in fact, in which Angel found out that of the true purchase price of the land. The ridiculous suggestion that someone would give somebody a contract to make to pay a commission of any amount after $3,000, when just of $3 million, when the property was first advertised at $6 million, and I must say there's nothing in the evidence to suggest at any time that Angel had agreed to $3 million. He was always complaining it was not enough. There was about $942,000 in non-refundable deposits. The property was in demand. And to suggest that you get a commission of anything above $3 million in those circumstances and suggest that this was a legitimate agreement, my Lord, we beg. So we are saying that the trial judge was quite right. It was within his rights. He was, if he's doing a case and someone comes before him and appears to be, takes the oath and appears to be an honest witness, and the judge finds that he is a dishonest person and a liar, can the judge not say he's a liar? If 2 people come saying that this is a genuine agreement, can the judge not say, well, this is a fiction? I don't believe any of you. Lord, I believe that this is a case where the appellant has failed to challenge the judge's findings on the credibility of facts. I wouldn't want to bore the court any further. I will just raise 2 quick points because my learned friend spoke a lot about commercial contracts and common sense.
Mr. Bruni, there must be very quick points.
Sorry?
There must be very quick points.
Yes, very quick, because I'm saying that we are saying, my Lord, that under the principles of the delegation, that the power of attorney could not be delegated. The powers under the power of attorney could not be delegated. There was personal confidence reposed in Gloria, and the power of attorney in any case has to be strictly interpreted. The business sense approach is in relation to the agreement, if it was legitimate, between Hilary and Gloria. And your lordships rightly pointed out that Gloria had no exclusive contract, so there's no exclusivity to go to agreement to Hilary. And the last point that I'd like to make is on the, I think my learned friend did one more point that I wanted to comment on. If you just give me 1 second. For the question of damages, my learned friend was claiming both damages and commission, or saying damages as an alternative to commission. There is absolutely no pleading for damages. The pleading is for the balance of the commission. And my Lord, sorry?
In the counter.
Sorry?
In the counter.
In this counterclaim, which is filed in this matter, is only asking for commission, so it wouldn't be entitled to damages. And I should point out again, we didn't raise it before, so I don't want to bore the court. But if one looks at the actual relief that is being sought in this appeal by the appellant, right? The relief which is being sought in this appeal, and I will refer to your lordships on page 16 to 17 of the record of appeal, is asking in paragraph 3 an order that the appeal be allowed and that the judgment of the High Court and the Court of Appeal be set aside and damages. So Angel is in this matter because we don't know if he was claiming any relief against us, and we didn't want to take the chance. So we're asking for costs in the matter.
Thank you, Mr. Bruni.
If you have any assistance, that's our presentation.
Thank you, sir.
Thank you, Madam.
Okay, Miss Gloria Burnette, are you there?
Yes, Your Honor.
Wonderful. I assume you have listened to everything that has been said. Do you wish to make any submissions to us?
What I would like to say, Your Honor, is that I'm relying on my previous submission on my matter, which is number 3 of 2018.
Yes.
And then the judgment given in this court on the 6th of February 2019, Your Honor. That's what I would like to, well, that's my contribution.
Okay, so you rely on the previous submissions and also on the judgment of this court delivered on the 6th of February.
That's correct, Your Honor, yes. So basically, I object to Mr. Shillingford's appeal based on your judgment given on that date.
Okay. Sorry, were you saying something else, Ms. Burnett?
No, Your Honor.
Yeah.
I've finished. Thank you.
Thank you very much. Mr. Mendez, did you?
Very quickly.
Yes.
As far as my learned friend's point on estoppel, we rely on our reply in full. Just to make 2 quick points, the authorities that my learned friend cites all deal with cases where a party was subject to a previous judgment and is then seeking to relitigate a point that was dealt with in that judgment in another forum. And the court held that it's an abusive process to seek to do so. As a matter of fact, the point is made plain in the authorities that the abusive process argument, the estoppel by record argument, applies where it is the same parties in the proceedings, in the earlier proceedings, that are now seeking to upend the finding in the previous proceedings. That is, of course, not the situation here at all. My learned friend has indicated that he is relying on the decision of this court in the Gloria Shillingford appeal as stopping us from raising the question concerning the alleged concoction. Of course, this court made no finding. This court did not uphold the decision of the Court of Appeal on the concoction finding because, as this court made very plain, there was no appeal on that point. So that there is no decision of this court on which my learned friend can rely in any event. So that his argument fails on that very simple point. Just very quickly, my learned friend has referred to his witness statement, paragraph 74 to 83, supposedly in support of the proposition that we had notice of the concoction argument, but nothing in those paragraphs indicate that he was alleging that there was a concoction. I will address the question that His Honor, Mr. Barrow, asked me to address, that is to say when an issue arising, a fraud arising during the course of appeal, course of a trial, whether the court is free to address it, and I will do that at a later stage as soon as possible with whatever authorities that I can find. My learned friend has made the statement incorrectly, and I think I need to correct it, that we did not challenge the learned judge's findings as far as the credibility of Hilary is concerned. We did in fact do so, and you will find that at pages 1791 to 1795, where we make the point that the judge's determination that Hilary was not to be believed was based upon his finding that Hilary was dishonest because of a transaction unrelated to these proceedings, in which he had registered a sale and for an amount which was below the actual sale price, and it was being said, well, he's being dishonest, he was trying to defraud the tax authorities. We have dealt with that in great detail to indicate that the learned judge simply misunderstood the circumstances, because the law provides that you are only to pay tax on the value of the property, and that is in fact what Mr. Shillingford was saying that he was doing. He put before the tax authorities.
But this arises in reply, does it?
No, it doesn't. I'm just correcting my learned friend who said that we did not address this point. So I'm indicating, I'm not going to go any further than I've just said. He was saying that we did not address the issue of credibility, and I'm saying that we did, and we went so far as to point out that the judge misunderstood the law as far as making applications for law in relation to the tax to be charged on transactions. And that is why he came to an error. But I'm just saying that we dealt with it in great detail, so my learned friend is incorrect as far as that is concerned. And that is all I wish to say.
Yeah. Thank you, Mr. Mendez. Okay, so there's just one matter of housekeeping outstanding, and that is the promise by Mr. Mendez to send to us any authorities that you can find on the issue of whether when an issue of fraud is raised in proceedings, a judge can in fact make a finding thereon. I gather you'll not, of course, be writing anything. You won't be making any written submissions. You'll simply be sending in any authorities that you find on that point.
Yes.
Yes.
Well, I would have, of course, in addition, direct your attention to any relevant paragraphs.
Absolutely. And Mr. Bruni, can we also ask a similar thing of you, that you also send to us any relevant authorities on that issue that you might come across?
Very well, my lord, we will, and we hope we find some that says that the judge be not.
I'm sure you do.
The judge can, I apologize.
Yes.
We hope we find saying that it can make a finding based on the pleas.
Wonderful.
Counsel, may I just urge in this regard that perhaps the two of you, before sending in material, may wish to speak with each other?
Very well, my lord. We
Yes.
would welcome that.
Yes.
Thank you.
Okay, well, thank you, Counsel, and thank you, Ms. Burnette.
Sorry, by
Yes? Do you have a date in mind? Couple of weeks?
1 week from today?
1 week, 2 weeks.
1 week, 2 weeks?
2 weeks.
2 weeks. 2 weeks is fine. Yes. So we will reserve for at least 2 weeks, probably a little longer, and we'll advise you when our decision is ready.
Thank you very much.
Thank you all.
Court rise.